Okay, so good evening all, and welcome to our review session for the second exam. So tonight will be much like our review session was for the first exam. Same kind of concept. I'll go over as many concepts as I can, review these concepts with you, but this is absolutely an opportunity for you to ask questions, so please do. If anything about the material is unclear, you're not sure about, you have questions about, certainly feel free to bring any of those questions up to my attention, and we'll try to get those addressed as best we can. So, insofar as the format of the test, it is very similar to the format of the last exam, insofar as the fact that it is 50 questions, a combination of true, false, multiple choice. There will be questions both from the lectures, and by the lectures I mean the PowerPoints and the voice-over PowerPoint information, the audio file that's on each PowerPoint slide. So make sure that you have obviously read the PowerPoints, but more importantly listened to the PowerPoint lecture, because there's a tremendous amount of material on those PowerPoints. There will also be information from the book. As you probably saw from the calendar, there was a significant percentage. Most of the reading kind of from the last exam until this exam was on contracts. I think there were like 6 or 7 chapters assigned for contracts. So just, you know, that's reading that you probably really want to make sure that you're focused in on, is the reading for contracts. More of the questions will come from the lectures and the PowerPoints. By lectures, I mean PowerPoints. Okay, that's what I'm implying. More of the questions will come from the PowerPoints than the book. I'd say that there's a greater percentage on the lectures and the PowerPoints than on the reading, but you'll need to do both, obviously, to make sure that you've got all of your bases covered. And of course, this exam review, you shouldn't be hearing anything new in this exam review, but we'll be solidifying some of the concepts and hopefully just deepening them a little bit. I tried to sort of give you examples in this test review of these application-based concepts, so that you have some level of familiarity with it when you're taking the exam. Any questions at all about the exam for me that you have? Yes?
Is anything about the Goldman Sachs going to be?
No. Nope. No. Nothing on Goldman Sachs will be. Nothing on Goldman Sachs will be on the exam. Your statutory research assignment, by the way, I had intended to release those grades today, and then Canvas fittered out on me this afternoon. So my entire plan of getting all those to you today sort of bombed on me. But they will be coming out very soon, so you can look for those this week. Any questions about anything administrative, housekeeping, anything like that? So, again, same procedures as last time with the testing center, so do make sure that you are communicating with the testing center about their hours to make sure that that you get there on time. Again, I don't keep track of their hours. I sort of let y'all take care of that based upon your own schedules and needs. So make sure that you find out about the testing center hours so that you can comply with their requirements. Okay, anything else on that before we go ahead and dive in? All right, so as a general concept, and this is a concept that we're going to talk about from now until the end of the semester, I want to talk about the concept of liability, because liability is an underpinning to business organizations and contracts, and will continue to be a critical issue when we get to torts, which is not on this test, but will be on the last test, namely the final. I'd like you to think about liability in 2 ways, because there really are 2 types of liability. When I say liability, liability basically means responsibility. Okay? Liability is responsibility. There are 2 types of liability. The first type of liability, for our purposes, is contractual liability. A valid contract between two parties creates contractual liability. Again, I'll say that again. A valid contract between two parties creates contractual liability where none might have existed before. So, for example, you go to the apartment complex across the street, desire to rent an apartment in that apartment complex, you sign a rental agreement, you sign a lease to rent an apartment for 1 year. Upon the signing and the execution of that lease agreement, which is indeed a contract between you and the landlord, contractual liability has now been created. Stated differently, each of the parties to that contract now have certain responsibilities, right? You, as a tenant, have a responsibility. What's your main contractual liability, your main contractual responsibility that you have as a tenant? Pay the rent. Precisely. You have that responsibility to pay rent on a timely basis. Did you have that responsibility to that landlord before you walked in and signed that agreement? No, of course not. Okay, they were strangers to you, right? But once you entered into that signed, executed agreement, contractual liability was created, and you now bear responsibility to pay rent on a monthly basis. What contractual responsibility does the landlord have? Give you access to the premises, right? They have a responsibility to ensure that there is a roof over your head, okay? You know, that it is a habitable premise, that the, what is represented in the lease agreement is what is provided to you. You sign a rental agreement for a 2-bedroom apartment. They have a contractual responsibility to provide you with a 2-bedroom apartment. Okay? They can't give you a 1-bedroom apartment. That would be violating their contractual responsibility that they have. So that's just a real basic example of what contractual liability is. But there's another form of liability that exists, and that is the liability that we see, the responsibility that we see, which is created by parties' actions or inactions, essentially as a result of negligence. Negligence is the main context in which we'll primarily be talking about liability, insofar as a created responsibility. And it is created by our legal system and created by our courts. Okay. You are driving down 39th Street. You are texting on the phone, you're texting, right? You rear end the car ahead of you. What liability do you have now?
You gotta pay your damages.
Right. You, absolutely. You are liable to the person who you hit due to your negligence in texting while you were driving. The liability that has been created is that you now owe this responsibility. You are liable to the person who you hit for the property damages, okay, the damage to their vehicle, and potentially for their any medical issues, medical bills, future medical issues that they might have as a result of the injuries that they sustained in the crash. Okay. Did you have any responsibility to that person driving the car ahead of you until such time as you rear-ended them?
No.
None, right? Had you not rear-ended them, no liability would have existed. Okay? So that's created liability. That's liability that was created by your action or inaction, depending on how you want to characterize texting while driving. Whether you want to characterize that as action or inaction, in any circumstance it's negligence, and so liability is created in that context. So again, kind of going back to that a little bit, when we're talking about in a business context with created liability, contractual liability, debts and obligations of a business, okay, when a business enters into a contract with another business for the sale of goods or the purchase of goods, those debts and obligations are contractual liabilities that a business owes. Anytime a business might cause harm or financial loss to another business as a result of, again, action or inaction, that's another kind of liability that a business could have. Failing to perform work. If a general contractor, let's say, is hired to do a particular type of work on a job, they fail to do the work as promised. The work completed is not within the scope of work. That's they now are liable for damages as a result of that. So, okay, does that all make sense? Everybody clear on those general concepts of liability? Okay, so when we're talking about business forms, there's one really critical issue that I want everybody to keep in mind, and it's this. We talked at length in these lectures about personal liability, right? And the correct business form protecting owners from liability. But there is no one business form that can protect a business from all its liabilities for its debts and for its obligations or for its created liability for its negligence, okay? The correct business form can protect the owners of the business from personal liability. But the business entity itself is always going to be liable for its own liability, for its own responsibility. Does that make sense? Okay? In other words, we don't have a business form where sort of if you check the right box on the Department of State form and create the, that all of a sudden you owe nothing, you can do whatever you want, you have no liability whatsoever. Okay? Business will be and will remain liable, but what we're talking about in all these different business forms is the extent to which and the variations in the different ways owners may or may not be personally liable. Okay. When I'm talking about personal liability, because again, we've talked about ownership of a business in a lot of different contexts in these business organizations, from being a sole proprietor, you just have your own business, to being a corporate shareholder. When I'm talking about personal liability and the risk that that bears, what are some of those risks of personal liability that I'm concerned with? What are some of the risks that you have if you are indeed personally liable? Take all your money. How can they take your money? It's not just taking the money out of your checking account, right? Oh, they can do that. They can sue. What are other ways of taking your money? Garnishing wages. Okay? That's actually one of the biggest things right there, the biggest concerns when we're talking about personal liability. Because I've had some people say to me over the years, and this drives me insane when I've heard people say this, I'm not worried about getting sued because I'm judgment proof. I've had attorneys say this to me in mediations, and it takes every ounce of self-control I have to not go across the, okay, breathe in. Let me explain to you why you're not judgment proof. When people say that they're judgment proof, they think that means it doesn't matter, I don't have any money, they can't get any money from me anyway. Okay. First of all, nobody is immune to a judgment. A court can issue a judgment against any individual or business that they want to. There is no special halo of protection that prevents a court from issuing a judgment against somebody or against an entity. What sometimes people mean when they say they're judgment proof is that they think that means, well, again, I don't have any money, so even if a judgment was entered against me, it won't matter because it can't be enforced. They can't get any money. Okay, that's a fair argument. I mean, that could be fair. You're not judgment proof because you could still get a judgment against you, but that judgment might not be enforceable to a practical effect. Okay. The only person that I can think of that is truly judgment proof, and they're not judgment proof because they can still get judgment against them, and they do, who can you think of that is truly?
The president?
No.
Doesn't he have
A judge?
somebody who's a handicap?
If a judge goes and rear ends somebody, he or she is just as liable as you or me.
Minor?
Nope. Well, that might be that. Then their parents are vicariously liable
Yeah.
for their acts of negligence.
Who's dead?
Well, then you're just dead. But you know what? Not necessarily, because your estate can still be found
Yeah.
responsible for your debts and obligations, and not even when you're dead.
Somebody with disability?
Nope. Because somebody with a disability can hurt somebody and commit an act of negligence and still be. I'm going to say this: somebody who's on death row.
Was they already dead?
Okay. They have no income. They have no future source of income. And unless you can buy lottery tickets in prison. Maybe you can, I don't know. I don't know if they let you do that at Stark or not, or at Rayford. But that's the only person that I can think of, I think, that is truly, in all likelihood,
Garnish their
their prison account.
Yeah.
Yeah,
I forgot what it's
so you
called.
can't get cigarettes and Snickers and
But if they had an
take your
estate,
$5 a week.
if they were a really rich person on death row, then their estate might be liable.
Well, I've talked to y'all about O.J. Simpson, haven't I? Have I talked to you about O.J. Simpson yet in this class? Okay.
I think you mentioned it in one of your lectures
Okay.
in some of the previous modules, but you didn't talk about it anymore.
He's a perfect example of somebody, and he's a rarity, quite frankly. Because, okay, so, brief little bit of background on O.J. Simpson. Is everybody generally familiar with the case? Okay, he was found not guilty of murdering his ex-wife and her friend. So he was not sent to jail for murder. However, Ron Goldman's family filed a civil action against O.J. Simpson immediately after the not guilty verdict was rendered, seeking civil damages for the wrongful death of their son. The burden of proof in a civil action is much less. The burden of proof in a civil action is that there has to be a preponderance of evidence that the individual caused the death of somebody. Whereas in a criminal case, it's beyond a reasonable doubt that they caused the death. So in other words, getting a criminal conviction is harder because the burden of proof is higher. As it should be. Because if we as a society say that somebody who's committed a crime, the punishment for that is going to jail, that the loss of their freedom, there should be a high burden on the state to prove beyond a reasonable doubt before that person's freedom is infringed upon, is taken from them, basically. But when we're talking about money, the standard's lower, okay? And indeed, the standard was lower in the civil action against O.J. Simpson, and the court, it ruled in favor of the family, finding that O.J. was liable to the tune of, I believe, about $10 million for the deaths of Ron Goldman and Nicole Brown Simpson. Okay? What makes O.J.'s case different than any other random first-degree murder case that's heard in our court system in our state every single day?
He's famous.
He's famous, but what else was he at that time?
Wealthy.
He was wealthy. Okay? He was wealthy. Most individuals convicted of first-degree murder are not wealthy. Some of them are. But if you're to do some statistical review of most people who are convicted of aggravated assault, robbery, first-degree, second-degree murder, you're not going to find a tremendous amount of wealth. Okay. Could somebody or the family of somebody who was murdered file a civil action against the murderer and receive a judgment in favor?
Yeah.
Probably,